Hi, this is Professor William Wagner, and it's Faith and Freedom Friday. Article 4, Section 1 of the Michigan Constitution provides that the legislative power of the state of Michigan is vested in a Senate and House of Representatives. Notwithstanding this provision in our Constitution of the state of Michigan, the Michigan Supreme Court recently handed down a decree that amended the Michigan civil rights law to add sexual orientation to the list of classifications covered by the law. Now, the judicial edict here wrongly usurped the constitutional lawmaking authority held by the state legislature in the state of Michigan. Likewise, the executive branch did the same thing when the unelected Michigan Civil Rights Commission pretty much did the same thing with regard to adding these classifications to the law. Laws should be amended and changed by the people's representatives. And so I want to commend the legislature this week for actually holding hearings on this issue. And so they finally have returned the question of whether or not to add all this additional classifications to the civil rights law into the right place of government. We're now back in the people's branch where everybody supposedly should be able to have the right to debate. Unfortunately, we're finding that there is not that transparency and that ability to engage in full debate like a democratic republic should have. We're at least in the right branch of government, and so I'm happy that we're doing that. But the problem is that these divisive preferential classifications in so-called anti-discrimination laws, they evoke passionate viewpoints. They evoke debate. Public policy decisions of this important type of magnitude ought to allow for input of all Michigan citizens and not just some lawyers wearing robe on the court. So again, I'm happy that we're in the right branch of government arguing and debating these issues. The problem is that there are serious policy concerns that are being completely ignored by the legislature. The current proposal is bad public policy. It's going to cost the state millions of dollars in lawsuits that they're going to lose when the law is inevitably unconstitutionally applied, because we see virtually everywhere in the country when these additional classifications are added that the government then weaponizes that statute in ways that are used to persecute and go after people with sincerely held religious beliefs, people that have and want to exercise freedom of thought and conscience, and in no way would ever want to discriminate against the person based on who they are, would never want to treat anybody with anything less than the highest amount of dignity and respect. But at the same time, they're not going to give up their sincerely held a religious conscience that calls them to do right and to not do wrong. So recent cases against bakers and printers and bed and breakfast proprietors are an illustration of how some of these laws have been weaponized recently. More to the point, I think, and more recently, what we're finding is a lot of these diversity, equity, and inclusion divisions of different corporations. They're using these type of provisions to weaponize and impose a politically left woke agenda on all their employees, and then they shame and punish their employees who have religious beliefs, and many of these folks face the possibility of losing a job and being afraid of losing their job. So you would think that if everybody is true to their word when they're testifying and when they are talking to the public from their politically elected positions, that they say they want to have equality for all and protect everybody against discrimination, you would think that they would add religious identity and religious expression to that long list that they currently are proposing. So that is our hope, that we can build a bridge and that we can, learn to, all, get along here. There is it's important to understand that amending this Elliott Larson Civil Rights Act as currently proposed will inevitably collide with the constitutionally protected conscience held by many religious people who acknowledge the invaluable differences between men and women. And as a matter of faith, that's what they stand on. People of the Abrahamic faiths, for example, recognize the differences in sex reflect God's nature, and that this difference is inherent in our status as being made in the image of God. So God created mankind in his own image. In the image of God, he created a man, male and female. He created them. And it's because that God made every human being, that every human being is worthy of dignity and worthy of being treated with respect. And that's why no Christian would ever discriminate invidiously against, somebody based on who they are. And that's not what's happening here. What's happening is these provisions are then being used in a way, after they're weaponized, to go after people because of their religious beliefs and the exercise of their religious beliefs, when they're exercising that conscience in a way that is not discriminatory in any way with regard to some kind of invidious intent. And so we need to go further, and we can be better. Every state that has added these provisions, these additional provisions for the left, they've also protected religious freedom and religious conscience. And, that's what should happen. That's what should happen here. So the same-sex marriage case, Obergefell v. Hodges, did nothing less than say that those religious ideas and religious conscience needed to be protected as well. And so we're hoping that a bridge can be built, and I encourage you to pray for that. In the meantime, as we fiercely stand for truth on this issue, we pray that everybody does so with compassion and respect, so that they can see the true heart of Jesus as we stand for truth. Until next time, this is Professor William Wagner, and it's Friday, so that means it's Faith and Freedom Friday. God bless you. See you next time.